and thank you for having me at the doctoral consortium of the International Conference of AI and Law. I am Diana Mocanu, a PhD researcher at the Catholic University of Louvain, at the Institute for Interdisciplinary Research in Legal Sciences, and more specifically in the Center for Philosophy of Law. And I will be talking today about my my doctoral research project entitled The Legal Status of Artificial Intelligence in the EU. Now, having really only just started on what is already shaping up to be quite a journey, I would like to first ask for your patience. I'm sorry, could I have your, oh, okay. It didn't seem to go forward. Okay, so I would like to first ask for a little bit of patience. I'm bound to have missed certain things. I have only just started last September on my doctoral research. And secondly, I'll be more than happy to hear your questions and suggestions, and they'll be precious to my research, I'm sure. And without further ado, there are a short terminology, precision. I will be throughout this presentation talking about AI systems, and I chose this terminology based on the European Commission's latest AI regulation proposal. There are, as you can see on the screen, quite a few other terminological choices that I could have gone with, but in the framework of my research, I've chosen this latest one, which is, of course, not to say that it's the best. It's just a contextual choice. So, without further ado, there are notoriously many legal issues raised by these uncanny entities. So it seems only a matter of time before the first hard cases involving them would start to appear before European courts and courts in general, which will doubtlessly require answering some very difficult questions, chief among which concerning the legal status of AI systems. On the answer to this central question, a host of consequences depend, or rather, this answer determines what legislation will be applicable and enforceable in relation to the practical uses and the ensuing consequences of those uses of AI. And there are, in my opinion, three possible answers to this. So the law could either treat AI as things, they could consider them persons, or they could create a new sui generis legal status for AI systems. I will attempt to answer this question by basically, the plan is to answer this question by systematizing the arguments in favor and against each of the three options that I listed before, to critically analyze those arguments that I have identified, to contribute new ones, hopefully. And all this is in order to sort of flesh out a portrait robot of the legal status of what the legal status of AI systems should look like in the EU. So the proposed research contends to systematize these arguments, and what is at stake here is not only the legal regime applicable to AI systems, to their use and the consequences of that use, but also the coherence of juridical humanism itself. And I will explain why that is. It has been argued that the current form of juridical humanism, widely accepted in Western legal systems and based on the dualistic division of reality into persons and things, is incoherent. And this incoherence stems in part from the de-reification of animals, so the fact that animals are no longer considered as things. Why so? Well, shortly put, because according to the modern theories of rights, animals are either already hold legal rights regardless of whether they are defined as legal persons because we have legal duties towards them, such as the duty not to mistreat them, And this is because the paradigmatic theory of legal personality maintains that a legal person is someone or something that holds legal rights and or duties. And so this is the first option. Or animals cannot hold rights regardless of whether they're declared legal persons. And this is according to the will theory of rights. But neither can, according to this theory, for instance, small children, who are nonetheless widely taken to be legal persons. So juridical humanism has been criticized. And moreover, certain views such as ecocentric anthropism have been proposed to replace the anthropocentrism that is inherent in juridical humanism. And I won't go into details, but this is a sort of more holistic view of a system that does not place the human at the center of everything, but sort of in a web of relations with the environment and other entities. And we see that this answer to the status question of AI systems seems to depend on larger questions, on our perspective of the law in general, or the context, which can either be represented by juridical humanism or not, as we have seen, or on whether one approaches law from a different perspective, such as maybe systems theory or functionalism or naturalism or legal positivism. And to give just one example of approaching law from systems theory, this would mean espousing the view that there is no compelling reason to restrict attribution of action exclusively to humans and to social systems, and that other entities can also be attributed action. The background for this is exactly the technologically triggered tendencies in private law that towards objectivization and de-psychologization. This is Gunther Twimmer's systems theory approach, which specifically applied to AI systems would mean that their social identity and their ability to act would make them, through social action attribution, non-human members of society. And the point is that their legal status should reflect this. Otherwise, gaps would arise, and there would be not only gaps in responsibility, as we have recently heard quite a lot, but also different kinds of gaps that cannot effectively be patched with traditional conceptual instruments. And his answer to the status question is three-pronged. So basically, he suggests three solutions. Either we can think of AI systems as actors with limited legal subjectivities, or actants, very much alike with what Bruno Latour said in his actor network theory. They could be treated as hybrids or a member of a human-computer association, or very much more vaguely as an element of a risk pool. But surely they're man-made artifacts, and we cannot forget that they are. However, they're also autonomous, adaptive, and self-learning. And these feature matter because they are highly anthropomorphic characteristics, which are generally uncommon in mere things. And they are autonomous in the sense that they have the capacity to initiate change in their own changes in their own program in order to better achieve certain goals. They're not entirely predictable, and they're not defined in a closed manner, so they're underdetermined. This is the terminology employed by Hildebrand and Coops to clarify the salience of autonomy. And then they are agents in the sense that they make decisions and they take actions in the world in order to achieve goals. And ontologically speaking, there's no difference between attribution of agency to humans and to other agents. So the question becomes, is it desirable to attribute agency to AI systems? And some say that it is, and some say that this leads to attributing personhood. And The European Parliament has itself in 2017 said so. It has suggested that creating a specific legal status for, in that case, robots would be a desirable thing, might be a desirable thing. In what concerns personhood, we should, however, be very aware of the fact that person, the concept of person, is a very abstract and ambiguous one itself. There are at least 3 different senses in which we can talk about personhood, and the one that I am referring to here is legal personhood. Legal personhood, which can either be attributed to humans, like the natural sort of personhood that we attribute to humans, with the not very insignificant asterisk of it being denied certain humans along history. And then legal personhood, the type that is usually associated with corporations. Okay. There is also a very, very important distinction to be made in legal theory about attribution or ascription of personhood. And there's a very famous debate between formalism and realism on whether there is or not a preliminary condition which is necessary for the recognition or ascription of personhood. Basically, a realist said that there is, and that condition can be either a soul, dignity, reason, or a sentience, or the ability to suffer, etc., or that there isn't, and then the question becomes, what is legal personhood then, or how do we think about legal personhood in terms of concepts? As for AI systems, the interest in the subject specifically, to my knowledge, has its debut in '92 with Professor Larry Solom's seminal article on legal personhood for artificial intelligences, which bears noting that, well, in 1992, there was little to talk of in terms of artificial intelligence, which arguably might still be the case, but it didn't mean that there was no further interest in the subject. On the contrary, it led to the development of a so-called relational approach, which we owe as a concept to Professor Mark Kokelberg, which I forgot to cite on my slide. But also, and so this relational approach means that basically the recognition of legal personhood for AI systems is linked to the condition that these agents must fit within our networks, our social networks, political, economic relations, etc. And interest in the subject has been growing exponentially lately, especially due to Professor David Gunkel's robot rights movement, which has garnered a lot of support for and against. Again, I won't go into much detail here. Suffice it to say, there is a very fruitful ongoing debate resulting in quite a few publications, mostly last year and this year, that I have briefly listed here. So surprisingly, I had started on this subject with the impression that there is not much literature to talk about, but lately that has come to change. So in legal theory, specifically, there is one quite recent book from 2019, Visakurki's A Theory of Legal Personhood, which proposes a new bundle theory of legal personhood, defining it as a bundle of interconnected incidents. So incidents are basically more complex, there are groups of rights, so to say, much in the way that property was described as a bundle of more simple rights. This means that entities such as AI systems, and the book dedicates a whole chapter to this problem, to the problem of AI systems. They could be treated as more or less as persons, based on the composition of the specific bundle of rights that are attributed to it. And it also uses the concept of legal platform to the case of AI system, for the case of AI systems, which I won't try to explain, mainly because I'm not sure of having completely understood it myself, which I'm hoping to solve by inviting the author to a webinar in our research center. And to go on, as I said before, but surely they're man-made artifacts, aren't they? And this seems to be the opinion that quite an impressive number of scientists and AI professionals and academics have taken ever since 2017 with the European Parliament's proposition. They are nothing more than tools, and legal personhood is inappropriate, both legally and ethically, whatever the status model they say. And this seems to be the case for most European Union regulation attempts. So the white paper on AI from 2018 does not identify legal personhood of AI systems as a problem, so no change is proposed. The 2020 resolution of the European Parliament thinks it's not necessary to give legal personality to AI systems, although it stresses that they are very high risk, and the fact that high risk is connected to their increasing level of autonomy. And indeed, this year in April, with the proposed AI regulation, the tendency to rely on existing interpretation of law instead of innovating in terms of legal status, of course, is once again apparent. So it just tacitly seems to be considered too much of a leap to give a different legal status than that of objects to AI. And I've been recently made quite aware of the fact that we should not underestimate the possibility that no clear course of action will ever be chosen in European Union instruments. And that personhood might well be too much of a leap, as opposed to just tinkering with liability solutions, with the liability solutions that we have, and just sort of wishfully thinking that we'll be able to attribute whatever harm will possibly arise to existing categories of natural and legal persons. Last but not least, my third proposed solution, so a sui generis legal status for AI systems, seems to count a wide range of solutions, from attributing specific rights, which sort of would mean attributing personhood if we rely on the definition of personhood that I've just quoted from the new theory. Then a partial legal capacity instead of personality was proposed as well, to do with the specific function that they have. Also, endowing AI with legal subjectivity was proposed, so yet again different from legal personality, or making them non-personal subjects as well. This all seems very complicated and well, maybe unnecessarily so. And it's something that I'm tackling in my hopefully forthcoming publication in Frontiers of Artificial Intelligence and Robotics, sort of gradient theory of legal status, Diana, of which I've only...
You have 2 minutes, okay?
Okay, thank you. I'm sorry. So I've included a Venn diagram of which asks the question where on this diagram would we include AI to hopefully make it clearer how the conceptual map of legal personhood or legal status in general would look like. To conclude and to systematize a little, we have different types of arguments. So we have moral and philosophical arguments of who counts as a moral subject worthy of consideration and what remains mere property. We have conceptual arguments about, well, basically conceptually engineering legal personhood and legal status to go to a more general level. And then we have pragmatic arguments of what is instrumental to promoting some kind of human good more effectively. the arguments relate to either the nature of AI, so philosophy of technology. They relate to the nature of legal concepts like personhood, so legal ontology, and the nature of the relationship between the two, so legal theory. They explore whether legal status attribution is based on pre-existing characteristics or if it's simply legal artifice. They question the conceptual coherence of juridical humanism and attempt to place it on maybe firmer theoretical ground, and they assess the practical implications of each course of action, each of the three courses of action possible in the case of the legal status question. I will focus on law in general and theories about law, or about what law necessarily is, but I will draw examples primarily from legal traditions of EU member states and positive law, and I will limit the scope to the lege ferenda suggestions to the EU. There's going to be an interdisciplinary layer, of course, which comes with the territory of the subject matter, I think. This is all from me. I look forward to your questions and thank you for your attention.
Thank you so much, Diana. I have our first question here. Could you elaborate on what a third option, AI as a sui generis, could look like?
Well,
just to finish the question, is a quite long question. If we are to create a legal fiction for AI, would this be similar to a corporation, for instance? If we were to create a legal fiction, AI as sui generis, such as the case for corporations, does the legal concepts about personhood, thinghood still matter as much?
Well, I think they do matter, and I think they matter in the sense that they maybe that they are sort of road signs, or they are useful in delimiting, or in, how should I put it, in creating a framework. So in what I propose as a gradient theory of legal status, basically the point is that you could be more, or you could have more or less of a status as a function of certain characteristics that, or I should say AI systems would have more or less of a legal status. And that legal status would vary, much like in the case of an RGB LED. I don't know if you can visualize that, but sort of legal status would vary between three fixed points. So basically personhood, thinghood, and then something in between, and then outwards, sort of. I should probably make a visualization of that to make it more to make it clearer. I think I've answered the question. I'm not very sure, but a sui generis legal status for AI is a very vague idea still. There's very little work on it, although there are propositions, like I listed the 4 different types of propositions to deal with AI systems in a sui generis manner. One of them, which I did not go into detail about, is the legal subjectivity one. So that's a very new proposition from a Polish scholar, Sylwia Wojciech, I think, if I'm pronouncing the name right, which basically joins my idea about a gradient of legal personality. It just doesn't call it a gradient as much per se, but it's basically centered on this idea of gradualized, or attributing or taking away rights in as to match the function of AI systems.
Thank you so much. I think we have time for another question. How to handle the legal status of AI as its liabilities in a very decentralized and collaborative scenario network? In other words, frequently AI systems are composed of multiple algorithms, database, and even multiple neural networks working together at the same time. Could one AI system be composed of multiple legal personalities? And if yes, how to determine which of them would be liable for a specific event?
Mm-hmm. Well, I think this joins that idea that I cited from Gunther Teubner's systems theory approach, in which he said that basically AI systems could be treated as members of a risk pool. I don't know if you recall in my presentation. I did not make a very big point about it, but it seems to be very vague in his writings as well. So basically, he doesn't actually tell us how that would be feasible in practice. Probably it would. Well, most likely it wasn't the subject of the article that I cite for this purpose. But the point there is that AI as members of risk tools could foreseeably be treated in terms of liability and responsibility as a whole. So basically, the whole risk pool should be liable. We don't actually know about specific details of liability attribution or distribution. Not from Gunther Teubner's in any case, but I'm more than happy to think about it. I'm actually probably going to have to, because as you point out, and I don't know who addressed this question, but as you point out, there are increasingly many distributed sort of applications of AI systems that will require very soon tackling this very issue.
Thank you so much, Diana. Now we'll hand it to our second presenter.
Thank you.
Maybe let's make
excuse me, I think that we still have like some minutes for a question. It's my pleasure to welcome Professor Monika Palmirani, who's just joined our doctoral consortium meeting here on Zoom. Good morning, Monika.
Good morning to everybody.
And we have a question here from Monika.
Okay.
In the chat.
Monika, would you like to make yourself a question, or may I read it for you?
No, please, you can coordinate, yes.
Okay, thank you so much, Monika. I have a question for the new proposal of AI, ACT, collocates the AI in the area of product connected with large existing regulation about liability or CE certification of medical devices. How your thesis could evolve to include also these new directions?
Yes, and thank you for your question. This will, of course, in the framework of my thesis, be included in the section about thinghood. And there's comparatively little legal theory work done on what thinghood is, I think. So hopefully by analyzing the recent history of EU regulation on the subject of AI systems and including the most recent one, which is this proposal for an AI regulation that you cite, well, I would hope to understand the sort of conception about AI systems that would permit me to further theorize. It would include this, well, I don't know if it's a new direction per se, I wouldn't say so. I would say it's basically sticking with the status quo. So treating technological development as things and attributing strict liability to it, or in the framework of the 2020 European Parliament Act, it would be basically making a two-tier system of liability based on high risk or ordinary risk, as they called it, which in my opinion is a bad idea. It's just treating very high risk things with a sort of liability, treating them, instead of treating them as strict liability subjects, as it would be according to the tradition of technological development, they just create this artificial two-tier system that sort of dampens some of the liability for ordinary risk AI. So I'm hoping to integrate all of this into a bigger picture about liability in general and how liability is used to treat technological developments such as these, and how it evolves in itself. Liability, I mean. Thank you.